Welcome to the Litigation for the Non-Litigious Company video series, a production of Womble, Carlisle, Sandridge, and Rice. I'm Sonia Pfeiffer, a business litigation attorney. I'm joined again by Press Millen, a trial attorney at Womble, Carlisle. In this final installment of Litigation for the Non-Litigious Company, we focus on our 8th pitfall, failing to learn from history. Press, what do you mean when you say failing to learn from history in the litigation context?
At a fundamental level, lawsuits are problems. Sometimes they're big problems. Nobody likes them, nobody wants them. But when litigation is over, very few companies make any sort of concerted or disciplined effort to understand the litigation and to learn the lessons from the litigation.
And when that occurs, what kind of problems are caused?
At the worst, what this can mean is the same problems that led to the first litigation can lead to the same types of litigation over and over again.
What's the best way to avoid the failing to learn problem?
The first thing to do is to make a commitment up front at the beginning of the case that when the case is over, no matter whether the result is good or bad, that the lawyers and the clients will sit down and make an analysis to understand why it happened and how it could be avoided or at least minimized in the future. Now, this is not something that you want to do immediately after the case is over because everyone is likely to be exhausted, typically not in an introspective mood, and really not in a position to reflect on the case. So instead, what I found works is to wait a month or so, give people a chance to rest, reflect a little bit, then sit down and discuss the lessons that have been learned.
Now, in your experience, has this worked?
It does work. In some cases, we've actually convened broad meetings of company executives to sit down and have in-depth discussions about all the lessons that we've learned from the litigation. Things that went well, things that went poorly, things that should be avoided, things that should be done again.
What are some of the lessons that are learned?
The potential lessons in this respect can really run the gamut. It could be something as simple as that the client's contracts need to contain certain types of provisions, like a choice of forum provision or an arbitration provision. It could be something like due diligence needs to include other areas or go more in depth. It could be something as simple as Joe doesn't need to be involved in exit interviews. In any event, the one thing I know for sure is if companies don't learn from litigation, they're probably doomed to repeat it.
Thanks for viewing this installment of Litigation for the Non-Litigious Company, a production of Womble, Carlisle, Sandridge, and Rice. We are a full-service business law firm with 11 offices from Atlanta, Georgia to Wilmington, Delaware. And we work with both regional companies in the Southeast as well as national companies. Womble Carlisle's lawyers are innovators at law. If you have questions about today's topic or related litigation topics, please feel free to contact Press Millen. You can find him at 919-755-2135. You can also reach him via email at pmillen@wcsr.com. For more information about Womble Carlisle, please visit our website, wcsr.com.